TuneCore took the position that our client is not a real artist, but went on to say our client is a scumbag, doesn't deserve the money, they will not release it to our client. I have released 1,200 videos on this podcast, and I've done that to educate artists and to help them to stay protected from predators in the music business. And this is the first time that I'm actually using my platform to call out a company that works so widely with so many artists. And it's because I'm shocked, I'm disgusted, I'm outraged, and I just really can't stay silent on this anymore. You know, apparently, artists now have to prove that they're real artists in order to get paid their royalties that they've earned from music platforms. Apparently, artists are now at risk of losing their royalties altogether, and music distributors just get to pocket the money or to give it to someone else, whoever they want. And apparently, some music distributors are okay exploiting artists and taking what really is likely hundreds of thousands of dollars that belong to artists. So I want to provide context. When we talk about music distributors, what we're talking about are essentially the gatekeepers. Okay, so if you want to get your music on music platforms nowadays, right, you have to upload your music through a music distributor. If you want it on Spotify or Amazon or Apple Music, so they're the gatekeepers. They're glorified banks. You go to a platform, let's say like TuneCore, you upload your music, you tell it where you want it to send all your music, it collects the monies that are earned, the royalties that are earned from those platforms, and they're supposed to put it in your bank account. They take a fee typically, and that's just what it is. Most of these music distributors do pretty much the same thing. They might have additional services, but they're basically meant to be the gatekeeper, to get your music onto music platforms, and you have no option other than that. So here's what happened related to TuneCore. My law firm, as you guys know, it's been in business for 9 years. From time to time, artists will lose access to their accounts. Okay, so like their distribution account, they might have their music taken off of music platforms. Things happen, right? And sometimes it's because there was an error, sometimes because there was a claim. There might have been copyright infringement, or someone's claiming there was copyright infringement. So distributors will yank the music off of music platforms, send notices to the artists, and sometimes this stuff gets escalated to me, right? I get hired as an attorney and they go, Krystle, I've been locked out of my account. The distributor has my money and won't release it to me. Please help. This is far and few. Artists do not have the luxury, usually, of having the money to go and hire an attorney. And this was actually the first time that I dealt with TuneCore, because I've handled this before. We send a letter to the distributor, we explain the situation, we explain more than anything else, and we just go, look, at the end of the day, you can kick artists off your platform. You don't get to keep their money. You don't get to just block them out and take their royalties, regardless of what you're claiming they did, which most of the time they're not going to even try to prove. So most of the time, we get the money back. We even sometimes get music reinstated. We get the account reinstated. Everyone's happy. So in this scenario, our client, who gave me authority to talk about this generally, hired us because his music got yanked from music platforms. TuneCore locked him out of his account. And in this case, there were tens of thousands of dollars of royalties here. And he had reached out, actually over the course of several years, trying to get help, trying to get a response, trying to figure out what was all going on. So our first kind of go at this, we started in December of 2023, and we always put together a demand letter, and we just explain the same thing that we say to all distributors, which is, hey, you can kick an artist off of your platform, you reserve the right to do so, but you don't get to take their money. We would like you to reinstate all the things, but more than anything, you need to release our client's earnings. They kick back, TuneCore goes, allegedly, our client had participated in, quote, store and streaming abuse, so AKA fake plays. So we believe there were fake plays on one or more songs, and therefore your client has forfeited his earnings. This was done without any kind of citation to case law, any kind of baseline other than we just did it. And so, of course, we come back and we're always going to cite to case law and give justification, all the things that usually gets the money released. In this case, we ran into quite some pushback. This escalated to a phone call. TuneCore didn't want to put anything in writing. So we have a little phone call and reiterated the position of, well, there were fake plays, and therefore it was a violation of our terms of use. We're going to discuss that. And I go, okay, interesting. Let's take a look at your terms of use. And in fact, let me pull it up for you right now. Here we go. So, and in fact, I'm going to go all the way to the top. We're going to have to scroll back, but I just want you guys to see this. Last updated December 11th, 2023. We sent our demand letter around December 1st, 2023. So this was updated not too long after that. I find that curious. Section 1, grant of rights. And if you go down, this was what TuneCore cited as justification for withholding our client's royalties. So if you go to F, Roman numeral 8, company shall have the right to retain and or redistribute to third parties any funds or the monetary equivalent thereof which TuneCore determines in its good faith discretion are attributable to improper conduct. In fact, let me even make it bigger for you. So let's go back to that again. Company shall, so meaning TuneCore, shall have the right to retain and or redistribute, to give it to someone else identified as a third party. That could be anyone. That could be my grandma, that could be my aunt, that could be my friend, it could be anyone. If there has been an allegation of improper conduct. So you ask, what's improper conduct? That's a great question. Let's take a look. So if you go to what is now section 1E as in egg, it goes, in the event the company has, in good faith discretion, reason to suspect that your account or recordings have been subject to, involved in, or generated revenue from violating the terms of service, fraud, infringement of copyright, trademark, right of publicity, or any intellectual property right, failure to comply with any third-party license requirement, or streaming manipulation, aka fake plays, collectively defined as improper conduct. So this was TuneCore's argument. They go, well, pursuant to our terms of service, which your client agreed to. And I go, well, did he agree to it? All right, most of the time when you upload, you have to click a little thing and say, I agree to your terms of service. I go, the time that our client's music was taken down was back in 2020. And I go, I don't have the terms of service from 2020. This says it was just updated like a few days ago. Odd. Can you send me the applicable terms of service so we can just take a look? All right, we're always happy to consider all the things, because at this point, we haven't seen controlling terms of service for that period, and we also have not seen any evidence. You're saying there was all this streaming fraud, fraudsters left, right, and center. So I have not seen anything. Produce the evidence, help me understand, and we can have a meaningful conversation. Because at this point, I'm the only one that decided to legal argument of why you're not allowed to keep someone else's money. So some time passes. And we come back and we go, look, we did some additional research, okay? Because the terms of service of which you are relying on are subject to New York law. In New York, and I'll show you our letter because you know what? You should see it. Pursuant to New York, it says that you cannot have what's called an impermissible penalty in contracts, okay? Because the terms of service is a contract. And that's what they're saying. They go, you signed our contract, agreed to these terms, so you can't go back now. And so we cite to New York law saying you cannot have a term in a contract that says some terrible penalty happens that does not equal an actual damage. So this is really important. If it does not equal an actual damage that TuneCore has suffered, they don't get to just say, we're just going to keep all your money, okay? This is important. So this is specifically what we said in the letter. While TuneCore's terms of service governing these accounts during the relevant periods in about 2020 remain unclear, like we have not received them. And any account earning forfeiture language, right? Forfeiture, which is what they're saying, you have given up the right to your money, even if applicable, is impermissible because it's a penalty under contract law and it's prohibited pursuant to New York law. And we cite to case law, which says, quote, whether a clause represents an enforceable liquidation of damages or an unenforceable penalty is a question of law, giving due consideration to the nature of the contract and the circumstances. An enforceable penalty clause is an estimate of the extent of injury that would be sustained as a result of the breach of the agreement, thereby embodying the principle of just compensation. Okay, so a bunch of fancy words that basically says that if you have in a contract, you go, if you breach the contract, you have to pay our attorney's fees. If you breach the contract and you do something that incurs damages for us, it's okay that we can recoup, let's say, your royalties up to the amount of that damage. That would be an appropriate way to structure this kind of language. That's not what that said, right? So when we were reading those terms, it's that they had a unilateral right to take all the monies and not even just to take it for themselves. They get to take it and pay it to a third party, whoever they want. That's what the issue is here. So we're having the call after this, okay? So once again, TuneCore doesn't want to actually put anything in writing and to actually, respond to us. So we get on this call, and this is like strike two, right? Strike one, didn't work. Our client must be a fraudster. We provide more case law, now specific to New York jurisdiction. Strike two, they come back and they just say, no. They go, even with that, of which we don't agree. Our lawyers have drafted this and we think it's ironclad. We believe that your client has committed streaming fraud and therefore we're not going to release anything. So we have a general sense of this. And on this call, what was just absolutely jaw-dropping to me is that TuneCore took the position not only that our client is not a real artist, but went on to say our client is a scumbag, not a real artist, doesn't deserve the money. It would be unethical to release it to him for all these reasons, and that they would be happy to release it even to a charity of our choosing. We just need to let them know, but they will not release it to our client. You know what that sounds like to me? That kind of sounds like something a dirty cop would do. So you go, you've broken the law, even if it's true, which we have not admitted to, and is not the case, of which I'm going to show you here momentarily. But even if we did break the laws on digital service provider platforms, and we paid for fake streams, TuneCore is taking the position they get to pocket that money. You don't get to take the drug money and put it in your own pocket and say you're enforcing the law. So at this point, we have not received any terms of use applicable to that period. We haven't received any kind of evidence that there was fake streams. And notably, this is the first time and the only time that TuneCore brings up the fact that Spotify is now going to be instituting sanctions. You guys all know about this. We've covered this. Spotify has made it very clear that for fake plays, music distributors, record labels, artists, you could get sanctioned if you get caught for fake plays. Besides the fact that we tell you just not to do it, it's going to destroy your algorithm. It's not good. I understand why people do it, okay? It doesn't make you a bad person, but you just don't want to do it. But now Spotify really is going to sanction. And I go, okay, I'm very aware of this policy change that just went into effect beginning of 2024. All the stuff that we're talking about is from 2020. Your new argument to try to save face is not going to fly. And more importantly, this whole withholding tens of thousands of dollars that don't belong to you out of your sense of personal ethics has no legal weight to it, is the most bizarre thing I've ever heard. And so we were at a standstill. Because at this point, as an attorney, I typically come back to the table with the client and I say, we're at a standstill. We need to sue. Straight up. This is conversion. They've taken it. They withheld it. They're not allowed to. This is my legal position. We should sue. But guess what the barrier is for the artist? Lawsuits are extremely expensive. And in those terms of service, there's also all kinds of language, a release of liability, a limitation of liability. If you do sue us, you have to go to arbitration. And they do all these things, so it makes it near impossible for an artist to actually enforce and protect their rights. So in a final ditch effort, we go, all right, it seems to be that this really isn't based in law whatsoever as far as TuneCore's position. So we would like to know if we can prove that our client is a real artist. He's paid for his marketing, he releases music, he's done all the things. He has followers on social media. We release his money, and TuneCore led us believe that they would. So over the course of now, we are several months into this. Our client has paid a lot of unnecessary money. But you know what? They seem like they're gonna play ball, so we keep going down this road. And this is some of the stuff that we provided to TuneCore. This is a screenshot from our client's Facebook ad account. And we've redacted, of course, his personal information. You can see right here, he paid $25,000 for this number of campaigns during this relevant time period. And because of that, here's what happened. These are some of the analytics showing, for example, up here, that he had received a reach of 19 million people who actually saw his content. And then if you look here at the summary, the total impressions was 161 million people. So to the extent that someone wants to take the position, say, I see that there was just, all of a sudden this huge spike of traffic, which is honestly one of the reasons this happens to artists and producers. Because, for example, the last time I was dealing with DistroKid, and the client made sleepy time music. And so it was music that would be streamed a long time as people are sleeping. And then he did a lot of ads on Facebook to drive a lot of promotion. So all this spike of traffic triggered Spotify to then be like, I think that this is fake plays, and then it notified the distributor, and then we had to go through this whole thing. But we got the account reinstated, we got the monies paid to the client, all the things. And so we produced this information. And we even went so far as to produce additional information showing things like beats that he had purchased, his social media following, just showing that he's an active artist. So we went through and jumped through the hoops. Guess what happened? Well, you guessed it. TuneCore took the same position, and they said, nope, I don't think so. We're not going to release the monies. And in fact, this is not the only time that this has happened. This is happening to a lot of artists. And in fact, just last week, Ben Jordan was complaining about this. And he posted, he goes, wow, look, his music had been removed for alleged streaming fraud. And so he tagged TuneCore, he tagged Spotify, showing his streams. And then after posting about this and making a stink about it publicly, his music finally got reinstated. I'm not saying that TuneCore provides crappy service. I'm not saying that you should leave their platform. I'm saying that I believe that this unlimited royalty forfeiture language is unlawful. In my opinion, it's exploitative to artists, and it needs to be revised immediately because this is a contract that hundreds of thousands of artists are signing, and this issue is happening across the board, which is why I go back to, we have a distributor, and potentially more than just this distributor, who is pocketing money when they decide that there is a credible allegation in the whole gambit of potential claims, which may or may not even be true. Someone claims alleged copyright infringement. Someone alleges fake streaming. And if the distributor decides, seems legit to me, without providing any proof whatsoever to the actual artist or even their attorney after months of attempting to resolve this. What I do think is reasonable is that distributors, of course, if they do get sanctioned because something happens, that there be reasonable language in their terms of service that says they can recoup in an amount that is equal to the damages actually suffered. Guys, I really want you to share this video with as many people as you possibly can, because maybe, just maybe, we can get TuneCore to do the right thing and to stop exploiting artists. I hope you guys find this helpful. Be sure to give us a big thumbs up and let me know your thoughts.